Rule 23 of the Rules of Court provides litigators with their most potent weapon for uncovering facts before a trial begins, the deposition pending action. But mishandling this tool can render months of expensive testimony completely useless. On the left side of this screen, Rule 23 operates during the discovery phase as a wide net. Attorneys can conduct sprawling fishing expeditions, asking questions to uncover leads, test theories, and lock witnesses into their stories under oath. Now look at the right side. You must understand the significant legal difference between merely taking a deposition to probe for weaknesses and actually using that deposition as formal evidence, which binds your client to the answers. To understand how this mechanism works, we are going to walk through the entire Rule 23 timeline linearly, from filing the initial motion to deploying the transcript in the courtroom. Mastering Rule 23 means you must constantly anticipate the trial judge's final evidentiary rulings while you are still months away from the courtroom. This legal mock-up shows exactly how the process begins under Section 1. Initiating a deposition only requires an ex parte motion. Thanks to the 2019 amendments to the Rules of Civil Procedure, the process is streamlined. You no longer need to wait for an answer to be filed or seek leave of court to begin discovery. You file the motion ex parte and you proceed. Pay attention to the phrasing in the rule, as it is a common trap on the bar exam. A deposition can be taken from any person. Depositions extend beyond the opposing party to include neutral third parties, hostile witnesses, or corporate officers. There is only one exception restricting this immediate access. If the person you want to depose is confined in prison, you cannot proceed ex parte. You must secure explicit leave of court. Once the deponent is in the room, Section 2 dictates the questioning. This radar graphic illustrates the relevant and unprivileged test. You can inquire into anything that logically pertains to the claim or defense of any party, provided it is not protected by legal privileges, like the attorney-client or marital disqualification rules. This scope is exceptionally broad. It includes asking about the existence, condition, and physical location of documents, or demanding the names and addresses of other people who might have knowledge of relevant facts. You use the deposition to find out where the actual evidence is hiding. Opposing counsel will often try to block questions by claiming the answer would be hearsay. That is the admissibility trap. During discovery, relevance is broader than admissibility. You are allowed to ask a question even if the answer wouldn't be allowed in a trial, because that answer might lead you to admissible evidence later. But while the subject matter is vast, the mechanical execution is heavily regulated. Under Section 3, the questioning must proceed exactly as it would in a live trial under Rule 132, starting with a direct examination and proceeding through cross, redirect, and recross. While the information you seek is boundless, the procedural method for extracting it remains strictly bound by the rules of evidence. Fast forward to the trial. You have a stack of written transcripts, and you want the judge to consider them as facts. You have now reached Section 4, the threshold where raw discovery data attempts to become admissible evidence. The foundational rule of Section 4 is strict notice. You can only use a deposition against a party who was present at the deposition, represented by counsel there, or who had due notice that it was happening. If they were shut out of the process, you cannot use the transcript against them. If you clear that hurdle, Section 4 provides specific paths to admissibility. Under Section 4A, any party can use any deposition to contradict or impeach the deponent. If a witness takes the stand and changes their story, you read their deposition transcript into the record to prove the contradiction. Second, under Section 4B, if the deponent is the adverse party themselves, you can use their deposition for any purpose. This acts as a formal party admission, entirely circumventing the hearsay rule. But if the deponent is just a regular witness, not a party to the case, this interface spells out the only way their transcript can replace live testimony, the DASU exceptions found in Section 4C. D stands for dead. If the witness dies before trial, the transcript comes in. O stands for out of the province, or living more than 100 kilometers from the place of trial, meaning the court will not force them to travel. S is for sick or infirm, rendering them physically unable to testify. U is when you are unable to compel their attendance via subpoena. And E is a catch-all for exceptional circumstances, where the court decides justice requires using the transcript. The logic here is absolute. unless you are impeaching a liar on the stand, using an adverse party's admission against them, or proving a strict dos u condition makes the witness unavailable. Live testimony in front of the judge is mandatory. Once a deposition is lawfully taken, it becomes an enduring asset. Under Section 5, if a party dies and is substituted, or even if the entire action is dismissed and a new case is filed involving the same subject and the same parties, those original transcripts survive and can be used in the new trial, but opposing counsel will inevitably try to block the transcript's admission. Section 6 dictates the timing of these attacks. Objections to the relevancy or the competency of the testimony are properly made at the trial itself, when the evidence is formally offered, not months earlier in the deposition room. There is a critical exception. If the objection is based on an error that could have been fixed immediately, like the form of a leading question, you must object during the deposition. If you sit silently and wait for trial, you waive the right to complain. This scale illustrates the severe tactical risk of Rule 23, outlined in Sections 7 and 8. There is a massive legal difference between gathering information and sponsoring evidence. Merely taking the deposition does not bind you. You can ask a hostile witness questions all day, and if their answers are terrible for your case, you simply leave the transcript in your briefcase. But the moment you introduce that deposition as evidence at trial, the scale tips. Under Section 8, you officially make that deponent your own witness. You only avoid adopting the witness under two specific conditions: if you are using the transcript strictly to impeach them on cross-examination, or if you are introducing the deposition of the adverse party. To maintain fairness, Section 9 ensures that at the trial, any party can present counter-evidence to rebut facts stated in a deposition, regardless of who originally introduced the transcript into the record. Crossing the threshold from discovery to evidence shifts the legal burden entirely. By using the transcript, you now sponsor the testimony. Because these out-of-court sessions lack a judge, the rules demand absolute neutrality from the officer administering the oath. This diagram maps out Section 13. A deposition cannot be taken before a relative within the 6th degree of consanguinity or affinity, an employee, the counsel of any party, or anyone with a financial stake in the action. However, Section 14 allows litigators to override these restrictions. If the parties execute a written stipulation, they can agree to take the deposition before any person, at any time, in any place, bypassing the default rules. If a deposition turns abusive, Section 18 provides an immediate tactical kill switch. A party or the witness can demand that the deposition be suspended right then and there, stopping the clock so they can file a motion in court to terminate or limit the examination. You cannot pull this switch just because the questions are difficult. You must prove to the judge that the examination was being conducted in bad faith or was designed to unreasonably annoy, embarrass, or oppress the deponent. Once the questioning ends, Section 19 requires the fully transcribed text to be submitted back to the witness. They must examine and sign it to authenticate the record, ensuring the stenographer didn't make errors, unless both parties waive this requirement on the record. And the rules do not tolerate wasted time. Under Section 23, if you serve a notice to take a deposition and then fail to show up, and the opposing counsel attends ready to work, the court will penalize you. You will be ordered to pay the attending party's reasonable expenses and attorney's fees. Rule 23 discovery is not a lawless free-for-all. It relies on strict officer impartiality, immediate tactical kill switches, and financial penalties to curb abuse. Oral questioning isn't the only option. Sections 25 and 26 offer an alternative: depositions upon written interrogatories. Instead of flying to another province to ask questions in person, the noticing party drafts their direct questions in writing. They deliver this document to a designated officer, usually a notary public, who sits with the witness, puts them under oath, and reads the questions aloud, recording the answers verbatim. Because opposing counsel isn't in the room to react, this method relies on a strict sequential ping-pong of deadlines tracked on this calendar. Litigators memorize this as the 10-5-3 rule. After receiving the direct questions, the adverse party has exactly 10 calendar days to serve their cross-interrogators. The noticing party then has 5 days to serve redirect questions, and the adverse party gets 3 final days for recross. This leads to a classic procedural trap. You must not confuse Rule 23 written depositions with Rule 25 interrogators to parties. They sound identical, but they operate differently. Rule 23 written depositions require an external designated officer to administer the oath and read the questions, and they can be directed at any person. Rule 25 is a direct paper-to-paper exchange strictly between the parties to the lawsuit, with no external officer required. Written depositions save travel money, but they trade the tactical flexibility of live, adaptive follow-up questions for a rigid, unforgiving clockwork of deadlines. Viewing the timeline from start to finish reveals how Rule 23 governs litigation. The rule functions as a two-phased operation. Phase 1 is the fearless extraction of data. Using the ex parte motion, you cast a wide net, where the standard of relevance easily overrules the strict trial rules of admissibility. Phase 2 is the surgical deployment of that data at trial. You must navigate the narrow gate of hearsay exceptions, satisfy the strict dossier unavailability rules, and carefully manage the risk of adopting a hostile witness as your own. When analyzing any deposition problem, start with a simple heuristic. Ask yourself, is the dispute about the right to ask the question during discovery, under Section 2, or is it about the right to submit the final transcript into evidence under Section 4? A deposition functions as a tactical asset. Executing the discovery phase with precision allows you to secure the evidence needed to win the case before the first witness is even called. Litigate smart.